Hello everyone and welcome back to law-clinic.eu. Every week I review the latest European legal developments on citizenship, statelessness and immigration law. This week's report is particularly interesting because it shows a clear trend across Europe. Nationality is no longer being treated as just an administrative issue. Instead, courts are increasingly recognizing that nationality is closely connected to fundamental rights, family life, and access to justice. One of the most important developments comes from the European Network on Statelessness, which highlighted the case of Suji versus Greece. In this case, a stateless Rohingya refugee was unable to provide documents that simply could not be obtained. The court criticized the authorities for insisting on impossible documentary requirements instead of considering alternative evidence and the practical reality of the situation. Another important development comes from the Court of Justice of the European Union in the Bukla judgment. Although the case was not directly about statelessness, the court reinforced a very important principle. People must have an effective judicial remedy even when authorities rely on classified information, especially where family life and the interests of children are involved. We also saw important reports from Belgium, Serbia, Slovakia, and Switzerland. Despite dealing with different legal systems, they all reveal similar challenges: documentation problems, unclear nationality, barriers to family reunification, and increasing questions about how authorities should deal with people who simply cannot produce the documents being requested. The United Nations also published new submissions concerning Moldova and Ukraine, highlighting children's right to a nationality, birth registration, and the protection of people whose documentation has been lost because of conflict or displacement. When we look at all these developments together, an important pattern emerges. European courts are asking different questions than they did only a few years ago. Instead of asking only whether someone has the required documents, judges are increasingly asking whether obtaining those documents was actually possible, whether children's rights have been protected, whether alternative evidence exists, and whether the administrative procedure itself has been fair. This represents a significant evolution in European legal thinking. Nationality is becoming not only a matter of administration, but increasingly a matter of procedural justice and fundamental rights. If this trend continues, it may influence future citizenship and statelessness litigation across Europe. If you would like to explore these developments in more detail, you can read the full article on law-clinic.eu. The link is in the description below. Thank you for watching. If you enjoy these weekly legal updates on comparative law, citizenship and judicial developments across Europe, please like the video, subscribe to the channel, and I look forward to seeing you in the next one.